Hello friends, we move to session 3 in this series on military law. In this session, we would examine as to what are the special features of military law. These are peculiar to dispensation of cases under the military law provisions, and therefore it is of paramount importance that we know that these stand as special features of military law. To begin with, I would like to highlight that law enforcement within the military parlance is known as command responsibility. As the name indicates, it is the duty, the responsibility of a commander that he exercises his power in a manner that is conducive to promotion of discipline and facilitates his task. At a unit level, it is the commanding officer who puts on two hats as a prosecutor and also then decides and disposes of the matters regarding violation of discipline that are brought to him or that pertain to the unit commanded by him. It would also do well for all of us to remember that every military man has a commanding officer who is his immediate superior and responsible to his or her discipline. Therefore, all at all channels, at all stages of military service, a person would have a superior who would usually be known as his commanding officer or act as such. The next term is the Chief of Army Staff, and that means under Section 3(4) of the Army Act as the officer commanding of the regular army. The next term is control, and this control in the context of Chief of Army Staff, he has been made responsible to the President through the central government for the command, discipline, recruitment, training, discipline, administration, and preparation of war of the army. Accused in the sphere of military law, in most cases, would be a person subject to the military law. He holds a military rank and is dressed in uniform at the trial. And even in those situations where the offense committed by an accused gets known, comes to light after he has ceased to be subject to Army Act, then the person is brought back in subjection and becomes a person subject to the military law. It is important to note that military law envisages the presence of the accused at all stages of the trial, and therefore the trial cannot take place in the absence of the accused. Accused is there, he participates in the trial, he knows what is alleged against him and which witness is stating what with regard to the crimes or offences that are included in the charge sheet that has been issued to him. If on account of the illness of the judge advocate or of the accused, before the stage of finding it becomes impossible to continue the trial, a court-martial shall be dissolved. And this is Army Act Section 107, Clause 2. Now this makes it clear that the presence of the accused is mandatory during the passage of the trial up to the stage of the finding, because that is where the conviction takes place and the court decides whether the accused is guilty, not guilty, or how to proceed with the trial with having due regard to the evidence that has been brought before the court. Judge advocate The term refers, it would clear to you from the definition there on the slide in front of you. Every general court martial shall, and every district or summary general court martial may be attended by a judge advocate. In other words, the presence or the attendance of a judge advocate is obligatory at a general court martial, in short what is called GCM, while at the district court martial or summary general court martial he may be there. Now, this judge advocate shall either be an officer belonging to the department of the Judge Advocate General, he should be a JAG officer, and in the eventuality that such an officer is not available, then he is an officer approved by the Judge Advocate General or one of the Deputy Judge Advocate Generals. They look at an officer who is suitable, has a law degree, has the experience of conducting trials, and such an officer may be nominated to perform the duties of Judge Advocate at that trial. And the relevant provision in this regard is in section 129 of the Army Act. The trial by court martial, there are two features that are worthy of appreciation in this regard, and I'm referring to Army Rule 82 and Army Act section 124. Army Rule 82 mandates that trial will proceed from day to day between hours of 6 in the morning and 6 in the afternoon, and minimum 6 hours of deliberation on any day. Now, this should make it clear that these ad hoc tribunals, like a court martial, they in this manner can complete their task expeditiously and with speed, because they move from day to day, and a trial is adjourned only if it is impractical. The place of trial, accused may be tried and punished in any place whatever. Therefore, as regards geographical jurisdiction, the commander who convenes that particular trial can order that trial would take place at a designated venue as decided by him. And for this, Army Act section 124 is the relevant provision. Another significant feature of military law is regard to challenge, and the relevant provision for this is section 130 of the Army Act, which lays down that at all trials by general court martial, district court martial, or summary general court martial. Now, these are the 3 out of total 4 ways. The one which is left out is summary court martial. I'll come to that later. At all these 3 types of court martial, as soon as the court is assembled, the accused would be asked whether he objects to being tried by any officer sitting in the court. In other words, an accused has been invested with a duty and with a power that he can object to an officer who has been nominated to serve at his trial, and he can object, he can put across his objection and the grounds on which that objection is based, and challenge that I do not want to be tried by this officer, he should not sit as a member of this court. Now, this provision of challenge is not applicable in the type of court martial which is at the lowest rung, known as summary court martial, because there it is the duty of the commanding officer to conduct the trial. Accused is not invested with the right to challenge him, but nevertheless, to balance that, the commanding officer is required to take an oath that he will well and truly administer justice, and therefore, while the accused has not been provided with the right to challenge him, it does not result in any sort of disqualification or prejudice to him. Now, how would a trial be conducted? With regard to evidence, it is laid down in section 133 that the provisions of Indian Evidence Act shall, subject to the provisions of the Army Act, apply to all proceedings before a court martial. And therefore, I wish to highlight that the procedure of leading evidence by way of the examination in chief, cross-examination, re-examination, questions by the court, or an expert evidence, a child evidence, the documentary evidence, the provisions of Indian Evidence Act, which are applicable throughout the territory of India, are also followed at a court martial. There is also in place a doctrine of double jeopardy, which prohibits a second trial. So an accused cannot be made to face trial again and again to his inconvenience, to his disadvantage, and section 121 of the Army Act has been framed, and which states that when a person has been acquitted or convicted of an offense, either he has been let off, he has been found that he has been acquitted, or if he was convicted of an offense by a court martial or by a criminal court, or has been dealt with under any of those sections relating to summary trial or summary disposal, which are section 80, 83, 84, and 85, he shall not be tried again for the same offense. So this firmly puts the doctrine of double jeopardy in place, and an accused cannot be hanged, so to say, twice for the same offense. Since military courts are a tribunal, all except summary court martial, therefore it would do well to appreciate that all decisions are required to be taken by absolute majority. So far as sentence of death is concerned, in the case of summary general court martial, this can only be given with the concurrence of all the members, and in the event of a general court martial, by 2/3 members of the court. Now, since death penalty is an extreme sentence, the capital offense, therefore, it can only be given in case of SGCM when all the members say so, and in the case of general court martial by 2/3 members of the court. The presiding officer has been authorized a casting vote in matters other than a challenge or finding or sentence. Therefore, except the challenge procedure, or when the court is deliberating on the finding or on sentence, except these three situations, the presiding officer, in the case of equality of votes, gets an extra vote known as casting vote. And the provision in this regard is section 132 of the Army Act. Another very prominent provision, an important provision, is with regard to confirmation, and section 153 of the Army Act lays down that no finding or sentence of a general district or summary general court martial shall be valid except so far as it may be confirmed as provided under this act. What did it mean? It conveys that both the finding and sentence of these three types of court martial shall reckon only after they have been confirmed. And how confirmed? As provided under the Act. So therefore, the Act provides as to who are the confirming authority and what are their powers with regard to confirmation. In certain situations, a court martial can be dissolved. It can be just put off. Now, what are these situations? This can firstly be done if once a court has started, it takes place, then if the court is reduced below the minimum number of officers. I'll explain this. It means that if it's a district court martial where minimum 3 officers are required as members, If the court, because of illness or death or unnecessary prolonged absence, is reduced below the legal minimum, the court shall be dissolved. The second provision is that if the judge advocate or the accused, any one of the two or both, fall ill and are not likely to become well fit to proceed with the trial, then a court martial is dissolved. And the last provision is relates to military exigencies or necessities of discipline. Say perhaps court martial is taking place, and at that point of time the entire army gets involved, a war breaks out, or any such eventuality takes place, then due to military exigencies or the necessities of discipline, Army Act Section 117 states that the court martial can be dissolved. And what happens if the court is dissolved? Since the court had not reached the stage of finding or sentence, and the accused has not been acquitted. Therefore, after the exigencies are over, or when the necessities of discipline so permit, the accused can be tried again, and double jeopardy would not be invoked because the accused did not reach that stage of finding or sentence. Another very significant provision is contained in Section 78 of the Army Act, where the prescribed officer may direct that any enrolled person sentenced to dismissal or higher punishment on active service may be retained to serve in the ranks. Now, this is important because should suppose a war break out and a person who has been sentenced to dismissal or higher punishment, that means imprisonment, there is active service and it is required that he should continue to serve in the army, well, then the prescribed officer may so order and he would be retained in the service. Now, from 2008 onwards, after the Armed Forces Tribunal Act came into force, there is an Armed Forces Tribunal, and this provision pertains to the jurisdiction of Armed Forces Tribunal. The Act of 2007 provides to the aggrieved person an opportunity to appeal, which was not there earlier. Earlier, there was an appeal by way of a petition, and in petition, post-confirmation petition, the accused was not heard, he could only submit in writing. But now with the Armed Forces Tribunal being in place, an accused can prefer an appeal where he can go and address the tribunal, or he can be represented by a counsel, and grounds of appeal relate to both service conditions as well as offences. Therefore, on these two counts, a person who is aggrieved by court martial can go to the court. By explaining these salient features, distinguishing features of trial by court martial, in other words, military law, they would very clearly indicate to you, on one hand, a resolve to maintain discipline, and on the other, to impart justice on the other. And therefore, it would have become clear that these provisions have been so designed that in no case should justice be sacrificed, and yet the need of the service to maintain discipline should also be retained. Thank you.